You've been charged with a criminal offense and you show up at your first court appearance and your lawyer puts the case over for 6 weeks to receive and review disclosure. And your lawyer shows up at the second court appearance and the Crown, lo and behold, announces that there's new charges being laid. There's going to be replacement information. And you go, whoa, I thought I was facing these original charges and now I'm facing expanded more charges. What's going on here? That's the video topic of the day. Can the Crown lay new charges after your first court appearance? And the easy answer to this, and which surprises people, is yes, they can. It depends on the situation, of course. What happens in a criminal investigation and criminal charges is the police initially will investigate and lay the charges that they think are appropriate. So let's say they charge you with assault or impaired driving, for example. And you receive a first court appearance, you hire a lawyer, it goes to that court appearance, and eventually your lawyer gets disclosure. And it finds out, the Crown later finds out, look, the victim received serious bodily harm, or on both the impaired and the assault. So now you're charged, you're faced, one person, they could lay a new information, charge you with impaired causing bodily harm, assault causing bodily harm, for example. There's many other situations. This is often done. It's called a replacement information. The Crown reviews the disclosures, say, hey, there's other potential charges here, or maybe the alleged victim in a sexual assault disclosed further incidents involving their kids or whatnot, or themselves, and new charges get laid. And this happens all the time in our system, and it does occasionally shock clients because they think they're bound by the first charges. They're clearly not. The Crown will review the disclosure and decide what's appropriate. And sometimes multiple new charges are laid. It really, every situation is different, and you have to be very careful on this. So I always say to a client, look, let's not assume this is the only charges. We need to get the disclosure, especially on a complicated case, see if there's anything else, because the Crown can lay a new information. Well, it's actually not the Crown that lays the new information. The Crown determines that a new information is laid, and the police lay that new information, and we typically call that a replacement information. Information can also be amended by the judge in certain cases. I won't get into that, but this is about laying a new information. So don't be surprised if this happens in your criminal case, because situations and facts evolve that the police learn about investigation. Sometimes, for example, a person could be charged with aggravated assault. The victim's sitting in the hospital. All of a sudden, we have a murder charge. There's some caveats to this now. We have categories of offenses in Canada. It's like dual procedure offenses, where the Crown can elect summarily or by indictment. There's no limitation period in that. So you could be sitting in court 8 months later and still get a new charge if it's an indictable amendment. They're out an indictable charge, because the Crown will just elect by indictment. But there's certainly certain summary conviction charges, such as causing a disturbance, low-level charges like that are single procedure. They're summarily, you can't elect by indictment. So they cannot be laid after 12 months. There's a limitation period. But indictable charges can be laid 40 years later, for example. So you could be 2 years into your prosecution and all of a sudden get a new charge. Another way that a new charges arise is sometimes in very serious cases, we will elect to have a preliminary hearing, which is a pretrial procedure where some witnesses go under oath. It's before the trial. It's advantageous in many times, but one of the problems with preliminary hearings, I don't want to characterize it a problem, but this occasionally arises. If new offenses emerge out of the evidence of preliminary hearing, the Crown can proceed on new charges for those. So they'll sometimes, new charges arise, and then you do a replacement information. So you have to be careful as a defense counsel, knowing whether new charges could potentially arise and weigh whether you should have a preliminary hearing or not in that situation. But typically, preliminary hearings are often strategically advisable on serious cases where they're allowed. And by the way, preliminary hearings in Canada are allowed only on cases of 14 years or more. So there you have it. The takeaway for you today is that, hey, if you've been charged with a criminal offense, it might not be the end of the story. You might go to court multiple times. The Crown might receive further evidence from the police, review the disclosure, and say, hey, I need to lay a new charge. So I'm going to direct the police to lay a new charge. And now all of a sudden you're facing more charges or more serious charges. That's the reality, unfortunately, for yourself in that situation in Canada, and that's the takeaway I wanted to give you today. Thanks so much for joining me today. If you like this video, please subscribe to our channel. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.